Thank you for coming to learn more about the implementation of the new pretrial fairness law. This morning we have two guests. I'm going to introduce our first person, Emma Gonzalez. Her pronouns are they and she. She goes by M. Emma is the outreach coordinator for the Illinois Network for Pretrial Justice. And I'm going to have her tell a little bit about what she does and tell us how this thing is going. Thank you.
Hello, good morning.
Wow, okay. That is very loud. I used to be a teacher, so I also feel like I project a lot, but good morning. As Pat mentioned, my name is M. Gonzalez. I use they or she pronouns interchangeably. You can also call me Emma. Anything with love I receive. And as Pat mentioned, I am the outreach coordinator at the Illinois Network for Pretrial Justice. So before that, I also volunteered with the campaign. And essentially what I do is things like this, reaching out for teach-ins so we can connect, hold each other through this new process and really hear how it's going. I know a lot of us in this space might have had experiences with pretrial jailing, might have known someone in our community, and this is something that we all really do together. This law was passed because of people power, because of organizing across the state, and we'll talk a little bit more about what that looks like. And yeah, I also have Ben Ruddell from the ACLU of Illinois. Ben, can I read your bio?
Sure.
Yeah, so I'm gonna read Ben's bio because it is great, and then if Ben wants to say anything, I'll pass it off to him. But Ben Ruddell is the Director of Criminal Justice Policy with the ACLU of Illinois. He is responsible for drafting and analyzing criminal justice legislation and lobbying in the Illinois General Assembly. And Ben joined the ACLU of Illinois in April 2015 after more than 7 years in the office of the Illinois House Minority Leader, during which time he held the position of Deputy Legal Counsel and staffed the Judiciary and Criminal Law Committees. Prior to his work in the legislature, Ben practiced law in Chicago. Ben is also originally from Peoria, Illinois. He graduated from the University of California, Berkeley with a degree in political science and received his JD from the University of Illinois at Urbana-Champaign. He lives in Chicago and is also a member of the Illinois Bar Association. So thank you so much, Ben, for being here with us, for being our policy expert. Can we give it up for Ben really quick? Yeah. And Ben, is there anything you want to say before we?
No, I'll wait till you get
Yeah.
to my part.
Yeah, absolutely. And so I think without further ado, we're actually going to start off with a video. I think I was supposed to say video to cue the series of events, just to kind of really ground us in what we'll be talking about today and really ground us in stories of people that are most impacted by this.
I had been up for like 3 days. I was extremely fatigued. Hair wasn't combed. I still had on my nightgown. When the judge told me my bail, I almost fainted. I couldn't move. I've lived on the south side of Chicago all my life. I have 2 kids. My son is amazing. He gets along well with his sister, but of course he's 5, she's 14. He feels like I'm in the house with 2 women. Sometimes he say, all I want is just peace. And we'll just look at him and laugh and say, did you hear what he just said? I was going through a divorce. A lot of things got bitter, and I had an altercation with my mother-in-law. I had no inkling that I was going to be arrested because I didn't start it. I was defending myself. After 3 days of lockup, I was taken to court. I remember going there and it sounded like you're at an auction. You can't talk to the judge, you can't say anything. Just stand there, put your hands behind your back. The judge assessed my bail at $250,000, $25,000 to walk. I'm like, I don't have a background. I've never been to jail. Why would my bond be so high? I'm 46 years old, and my entire life was determined right there within 30 seconds. I was in jail for 14 months. I lost my business, my housing. I couldn't see my kids just because I couldn't make bail. In the end, I took a plea, not because I didn't think I could beat the case, but because I needed to be with my children. they had already suffered enough. I don't think that society is really understanding when you incarcerate women, you're incarcerating the whole family.
Thank you all so much for watching that. I want to invite everyone to take a deep breath, just because I know that that can be a lot to take in, to really think about the realities that people face when they're, again, jailed pre-trial, they're taken away from their life. We'll talk a little bit more about what that looks like. And I forgot that I had a clicker right here. So again, take a deep breath. Of course, you know, this is your church, this is your place that you come to every Sunday, but just a reminder, if you need to use the bathroom or take care of any needs, please always feel free that you can do that. So a little bit of an overview, we're gonna talk about who we are, the impacts of money bond and pretrial incarceration, how money bond works and that functions. So again, we're operating now, or we're gonna be talking a little bit about the old system, but that's a really good foundation to understand that new system and how that works. We'll get into the Pretrial Fairness Act, what that looks like, how it makes our communities safer, and what we're up against. So even though that the law is going into effect right now, there are things that we're still kind of working through, or just that we are actually working through, not kind of, in terms of misinformation, doing court watching, making sure that we're holding the courts accountable, and then just other ways to get involved as well. So I wanted to talk a little bit about the Illinois Network for Pretrial Justice. So in 2016, different groups within Cook County formed the Coalition to End Money Bond under this idea that we wanted to get rid of money bond, that we wanted to really address some of the issues around pretrial jailing, and we were able to essentially reduce the population of people within Cook County within those jails by 50,000 people. And when we're talking about Cook County specifically, we were able to reduce it, I believe, by like 40% or something of that nature. However, with some of the reforms that were passed, there was this idea that, you know, that wasn't enough to fight mass incarceration, to, again, really understand the scope of the issue, which is why we convened into the Illinois Network for Pretrial Justice in 2019. So around 40 organizations across the state, from religious-based groups, from policy and advocacy groups, education groups, grassroots organizing, so on and so forth, essentially all came together to cultivate that people power so that we can really address this issue of money bond, to abolish money bond and come together with that. And that essentially, to address the root causes of socioeconomic and racial disparity in our legal system, that we kind of had to, you know, do something with this law. So again, this law came out of 2020 with the Illinois Black Caucus, and passed in 2021, and we'll talk a little bit more about what that looks like. And of course, you know, if you want to hear more about those organizations, learn more about them, you can go to endmoneybond.org. But you know, the UU churches have been a really great site of organizing for us. There's always been just amazing groups and people getting involved to have these presentations, and that's also a part of it. You know, like I said, a lot of this is from people power. A lot of this was done in relation to each other, which I think is really great in a lot of ways. And so now we're going to talk about the effect of money bond in Illinois. So we have 91 jails across 102 counties in Illinois. So more than 250,000 people are incarcerated in Illinois jails every year. And so with that, it's not at any given period, but just that revolving door, because jails are that revolving door, people coming in and out with that. More than 90% of people are incarcerated pre-trial, and most people are incarcerated because they can't afford to pay a money bond. And so with that, you know, when we're thinking about the COVID-19 pandemic, there was a paper from the Journal of Health Affairs that actually tracked that 1 in 6 COVID cases could be traced back to Cook County Jail. So really identifying that issue of, again, these jails are these revolving doors. We're keeping people pre-trial that, again, they haven't been convicted yet. They're there simply because they can't afford to pay a money bond. And then they are also, you know, getting COVID-19, and then unfortunately they're also dying, or they're spreading it to their loved ones as well. So just to really kind of think about the scope of the issue. Similarly, some of the other things that I want to point out is that when we're thinking about the people that are unable to pay a monetary bond. 75% of people in Cook County Jail are Black, yet they only account for 25% of the population. So then when we're thinking about, again, those racial disparities, the types of people that are locked up or that face incarceration, we're able to, again, pinpoint that this is a form of racial discrimination. This is a point of oppression for a lot of people as well. Is there anything else that's coming for mind for folks as they're seeing these numbers, or as they're seeing just kind of the effects of money bond, or that they want to bring into the space? And if the answer is no for now, just kind of taking it in, that's totally okay. So this is how the old system worked. And it's so interesting to be able to read that because I've given this presentation to talk about the current system. And I'm still getting used to saying it. You know, this is how the old system worked. And again, like I say that with a lot of, you know, hope for the future, that the way that the system works is going to be more equitable. It's going to keep our community safer. And that also, you know, we're really working towards a more just and fair system. Again, that pretrial fairness system. So I also want to acknowledge that a lot of people, again, might have already had an experience within the old system, maybe someone that they know. But if people could give me a thumbs up or a thumbs down, how many of us are pretty familiar with how the old system worked? All right, so I like the medium thumbs. Like, yeah, maybe some of us. How many of us feel comfortable explaining how the old system works? No one? Maybe? Okay. I was going to say, well, if you want to take this slide, but it looks like no one. It looks like it's going to have to be me again. So again, you know, something that even Pat and I were talking about earlier, just as we were kind of gearing up for this presentation, is that the old system was very confusing for folks. A lot of these hearings were determined in 1 to 3 minutes. You know, people weren't necessarily sure what was going on, and that's also on purpose. You know, it can be very overwhelming. That also adds to those disparities, that adds to those outcomes of people within kind of this snake pit of how the old system worked. So before, someone would be arrested and charged and booked, and then they would have their bond hearing. And for some people, they might receive an I bond, which is a non-financial release, so that can also be a signature bond or a recognizance bond. But then for a lot of people, they would have to pay a money bond, which would be their financial release. Again, the issue being that most people can't afford their money bond. So then they were incarcerated pre-trial. And that time period in which they were incarcerated to their actual trial could be days, weeks, months, or in Levette's case, 14 months, over a year, before they actually had their day in court. And a lot of studies show that even the trauma of being incarcerated for a day or two can really upend someone's life, let alone being incarcerated for an extended period of time. And with that, you know, another story that I like to share is about Khalif Browder in New York, who was incarcerated pre-trial from 2010 to 2013, so for 3 years, for allegedly stealing a backpack. So again, that's time that's taken away from people, time that they're not able to work on their defense. I also do a lot of work within sexual and domestic violence. So a lot of the people that I work with, you know, would be arrested for petty theft because their abuser controlled their finances. And then again, instead of getting met with resources or support, we're met with incarceration. So that's a little bit how the old system worked. Also, I'm going to turn to Ben, but Ben, is there anything else that you want to mention about the old system just within your work?
I guess the only thing I would say is even under the old system, prosecutors and judges in some circumstances did have the option of detaining somebody without a bond, so they're in jail but cannot secure their release with a bond. But that option was rarely utilized under the old system because it was much easier for prosecutors to just ask for a high money bond, that if they wanted to see somebody detained, to ask for a bond to be set in an amount that they didn't believe that the individual would be able to pay, or their loved ones wouldn't be. That practice is unconstitutional, by the way, but it's the really kind of been the linchpin of how pretrial court works in our criminal legal system, is setting unaffordable money bonds rather than, you know, talking about the issues that lead a prosecutor to want to detain somebody or not. issue of how much somebody has in their wallet completely out of the picture.
Yeah, thank you so much for that, Ben. And I think something that, as Ben was talking, that came up is that, again, Black and brown people are the least likely to actually secure an I-bond as well. So again, really painting that picture of who this affects. It does affect everyone, but we know that specifically for communities of color, that is a big point of racial disparity as well. And so now we're going to talk a little bit about the harms of pretrial incarceration. And there are several layers to really think about when it comes to that harm. But before we get into it, what do you all think? What are some of the harms of, again, being incarcerated pretrial? Again, not able to afford your money bond, and then you're incarcerated. Yep.
I just think, like, you were talking about the trauma not only of being incarcerated, but also on, like, that individual's family, their children, like, to have a parent suddenly taken away before you're even gone to trial or been at trial, and yes, sometimes up to a year or more. It's traumatizing in a generational way, even.
Yeah, thank you so much for that. Yep.
Well, your job would be in jeopardy.
Yeah, your job could be in jeopardy. Absolutely. I don't know many jobs where if you just don't show up, they're going to be cool about it. You know? Anyone else?
You lose your housing.
Yeah, you could lose your housing. Absolutely. And could you say a little bit more about that? Just like if you pay rent, things like that? Yeah, absolutely. How many of us, and we don't have to disclose or raise your hand, but take medication every day? I take medication for specific chronic illnesses. If I'm in jail, I might not have access to those things. Anything else coming up for people? Yep.
If you don't have family who could take care of your children are then taking the protective custody.
Yeah, absolutely. Anyone else? Any other thoughts or ideas? Yep.
I think we haven't mentioned the psychological effect of losing your freedom and being boxed up. I think that would drive me right over the wall.
Yeah, absolutely. You're taking out of like a familiar setting, the comfort of your own home, and then you're taking, like, your freedom is taken away, like your movement is taken away. Definitely. Maybe one more thought before we also get into it? Yeah, okay.
For your health, you don't exercise much, you don't eat good food in jail, you don't sleep well, just general health goes down, I can imagine.
Yeah, absolutely. And I think with that, a local group, Cook County Community Jail Support, was posting about how they're getting reports of unclean water. And it was during some of the hottest times of the year. And so it's like, if you need to take care of your bodily needs, you can't really do that. And so actually being in tune with, like, what do I need? And similarly with that, being unable to do so, I think some of the other things that I think about is that, when we're thinking about public benefits, if you're in jail for a certain period of time, you have to reapply for them again. If you are somebody that is queer or part of the LGBTQ community and you take hormones, you might not have access to the gender-affirming care that you need. When we're thinking about the Stop Cop City protests in Atlanta, somebody was jailed pre-trial and they were the caretaker of an elderly disabled parent. They were the sole caretaker of that person, and then they were unable to do so because they were incarcerated pre-trial. And so there are a lot of harms that come to this issue. And I really appreciate that I've heard actually some like different ones that maybe don't come up in terms of like not being able to take care of your body, take care of your needs. Yeah.
I think the fact that it's so disproportionately African Americans that get jailed pre-trial,
Yeah.
it just feeds into like the stigma and the stereotype that, well, Black people must commit more crimes.
Yeah, absolutely. And so we're even talking about like that harm within it of itself. I think something that that reminds me of is I went to a panel with specifically Black survivors of domestic violence. When they were incarcerated pre-trial, they would talk about, I would be in front of a judge in this like jumpsuit, in this uniform, and then there's stigma attached to that. I'm not able to have access to makeup. I'm not able to, represent myself in the way that I feel good about myself. I'm not able to work on my defense because they know, I'll be racially profiled because there is that stigma that exists, absolutely. I mentioned Khalif Browder earlier and then talking about some of the mental anguish that people experience. Khalif Browder, unfortunately, is no longer with us. He did die by suicide, and then his mother actually died from broken heart syndrome. So that was what the autopsy had said with that. So really thinking about the effects of the whole family with that. And he I don't want to share him merely as an example. I encourage people to read about him, again, as someone that should really be here with us, because these stories matter, these people are important, and they're people that should still be here with us today. And that's why it's really important that we're really thinking about, how are we making sure that we're returning people to their community? How are we making sure that we're actually in conversation with each other about some of these harms as well? Yeah, I think we'll go on to is there anything else that people want to add? Oh, wait, what'd you say?
Sorry.
I think I heard a comment over here.
How do you spell Cleve?
Khalif, absolutely. So it is Kalief, Khalif Browder, in New York. So he was incarcerated at Rikers. And then, yep.
Just feeding into the prison pipeline, the problem with that, and also the cost to the taxpayer of
Yeah.
housing people who probably shouldn't really be there, but we're paying for. And it's not even being cared for, and they're not even being treated like human beings, so that cost, I mean, if you're looking at it from that perspective, the cost to the taxpayer. Some people, that's what's assessed to them.
Yeah, absolutely. And I don't have this precise number for adult incarceration, but when we're thinking about youth incarceration, it approximately costs $117,000 to incarcerate one child in a youth facility. And when we're thinking about the money spent in schools, that's about $40,000. So I do work with an organization called Liberation Libraries. We give books to young people that are incarcerated, and within our research, that's something that we found out. And it's, I would imagine it'd be similar for adult populations or for adult incarcerated people. But yeah, it costs money to incarcerate people, and that could be money within our communities, money for things like schools, money for things like transportation, things like that. Any other thoughts? And I think there are microphones as well for people. Perfect, thank you so much. Yeah.
Sorry, I'm being sneaky back here. Honestly, the thing that struck me is how all of this compounds. Maybe it's who's going to care for your children for a couple of days, and then for a longer period of time, and then they get taken away because you can't work and you can't afford your rent. And now, instead of being a person with one problem, you're a person who has all of these problems, which as a society tells other people, are they really a fit parent? Are they really trying? They lost their job and their house. What's going on with them? And so it's this one bad move potentially that causes all of these harms that really aren't the person's fault, it's the system's fault.
Yeah, absolutely. It looks like we have someone back there.
And that person is innocent before proven guilty, or guilty, essentially, before proven guilty.
Yeah, and I think that's a big thing is regardless of what the offense charge is, there actually hasn't been a conviction yet, so actually thinking about that. So we'll do 2 comments and then we'll move on.
I just had a question.
Yeah.
Of the people that are incarcerated pre-trial because they can't afford to get out, do you know what percentage of them are actually then not convicted, but this whole upheaval happened in their life anyway?
I don't know that. Ben, would you know that?
I don't know that we have good numbers on that, but certainly we can. There are examples of individuals that we work with who have spent significant periods of time incarcerated pre-trial, only to ultimately not be convicted of the charge. So we certainly know of real life examples of that happening, that I couldn't put a number on it. Sorry.
Yeah, one of somebody that I'm really close friends with that I sent books to when they were incarcerated spent 2 years on electronic monitoring, only to be found not guilty. And then I think spent an additional 2 years also in jail. So 4 years total. Yep, and then we'll take one more.
Yeah, I think this all boils down to it's not fair. It's financially unfair. If I got arrested for something, I guarantee you my hopefully friends and family and myself could conjure, together the money to keep me out of jail for any period of time, whereas somebody who is not, able to do that goes down this compounding road of, it kind of reminds me of the compounding road of poverty, the things that happen when you're born into poverty. And so that is, I'm guessing, the core of this issue is the unfairness, and to eliminate that. And this is astounding to sit and talk about the compounding effects of this, and it would really help everybody. in literally, everything from the state's budget to that person's life. Like it helps everybody and everything to eliminate that financial component of this.
Yeah, absolutely. And then just hearing you talk, something that I forgot to mention is that while we're the first state to abolish money bond in this way, there are other states like New Jersey that have virtually really not relied on cash bail for a very long time. And it actually coincides with a drop in crime rates because as something that we're talking about, that poverty spiral, is that a lot of people will turn to the shadow economy or into other ways that are criminalized for their survival because they're like, you know what, I lost my job, I need to do something. I need to make sure that my family eats. I need to make sure that I make rent on time. So then people are given other options and they're like, you know what, I am already kind of within this. I need to, again, survive. That's why I brought up the example of survivors that are arrested for petty theft or for stealing. It's not something that they want to do. It's not because they're bad people. It's because they need to survive. They need to feed themselves, they need to feed their kids, and because of the circumstances that they're in. And so again, pretrial freedom really matters because of that. When people are incarcerated pretrial, they're 4 times likely to be sentenced to jail. So again, they want to return to their life, they might take a plea bargain. There are 3 times a greater likelihood of being sentenced to prison time. They will have longer, again, jailing sentences, longer prison sentences, and then during the pretrial period or for year after that. And so again, we actually have the data and information that when people are not incarcerated pretrial, that we actually do see, again, that drop in crime rate as well, because we're not destabilizing people's lives. They're able to maintain their jobs, they're able to maintain their support systems. That really matters. So again, we're thinking about how are we actually creating that stability and also for people to work on their defense. So I think something that was brought up in several different capacities is that we know, again, Black and brown people are more likely to experience racial profiling, being arrested, things like that. And so that's why being able to work on your defense is really important. And so I wanted to get to this part because I'm actually going to pass it over to Ben, who is going to take us through a walk through the Pretrial Fairness Act and what it looks like. So like I was going to try to say something really clever here, but this is like the most exciting part, what this new system looks like. And so hopefully all these things that we're talking about, that the Pretrial Fairness Act is going to create that more just, that more fair system in society. And again, thank you all so much for being a part of this today as we're looking forward, as we're, again, seeing how this unfolds. So Ben, I'll pass it to you.
Thanks, Sam. Great job. What I'm going to do now is walk through the new law, the Pretrial Fairness Act, that replaces the system that's so rife with problems that is unfair and unjust and actually doesn't promote safety because it destabilizes people's lives. The last slide M had up here showed that people are actually much more likely to be rearrested in the future if they've been incarcerated pre-trial. So when we think about what this system is supposed to be for, it's supposed to be for safety, and yet we're causing more crime by using jails for people who are supposed to be presumed innocent. So the new law, eliminates money bond. Everybody knows that, but it doesn't just eliminate money bond. It remakes the pretrial system in a way that is intended to be more fair, more just, and actually to center the questions of safety that have always, that haven't been focused on or addressed by the old system. So first principle, walking through this law, we're going to kind of use the principles of our network and that underlie this law as a kind of roadmap through the law. So the first principle, obviously, money should never be a determining factor in whether somebody is free or in jail pending trial. It's just not a fair way. It criminalizes and punishes people with less resources. And it's just an incoherent way of making this important decision. So what are we doing instead? So under the Pretrial Fairness Act, a guiding principle is that release should be the norm and detention should be the carefully limited exception. And when that may sound a little bit like legalese, that's because that comes directly from a U.S. Supreme Court decision, that in fact is supposed to be the law. Release is supposed to be the norm. Detention is supposed to be the last resort. And because of all the negative impacts that we just talked about, that we should use detention very sparingly, and that's what the Pretrial Fairness Act does. So instead of putting a price on somebody's freedom, what we're doing instead is having the judge ask questions about whether an individual, if they were released, whether there's evidence that that person would likely do harm to somebody else, or would be a risk of not coming back to court, with willfully fleeing prosecution. Those are the only real legitimate legal reasons to hold somebody in jail who's entitled to a presumption of innocence pre-trial. And so under the Pretrial Fairness Act, we're going to focus on those questions. So in doing that, the bill creates what's called a detention net, which dictates that only people who are charged with serious offenses are eligible to be detained in jail in the first place. So your less serious charges, ordinance violations, low-level misdemeanors, nonviolent type charges, in general, on a person's first court appearance are not eligible for jail, but charges involving violence or sometimes weapons, those charges that are considered more serious are eligible for detention. That doesn't mean the person's necessarily going to be detained. It's still a case-by-case, fact-specific basis. So the way the law works is when a person is charged with something that's eligible for detention, then it's up to the prosecutor to determine, do they want that person to be detained? And if they do, then they need to tell the judge that and explain why they believe the person, if they were released, would either pose a danger to somebody else or would be unlikely to return to court. And so if the judge agrees, then they can hold the person in jail pre-trial, and there's no amount of money that will secure the person's release in that case. Money is out of the equation, but if the prosecutor doesn't ask for detention, or they ask for it and the judge doesn't feel that the prosecutors met their burden of showing that that person's a danger to others or likely to willfully flee, then they will be released. They may be released with conditions, but they're not going to be held in jail. And a problem with our current system is a lot of people spend time in custody for minor charges, and so the detention net ensures that that doesn't happen. And it also, one of the guiding principles of this this legislation, and one of the goals of our network, is that we have fewer people incarcerated pre-trial. We won't see this law as a success if you see jail populations stay the same or increase. And without this element of the detention net, you could really see that happen because, remember, you're in or you're out. There's no question of raising money to secure your release, which cuts both ways, right? Because currently people who are held in jail now, a lot of people do secure their release by paying a money bond, and often paid by their loved ones, people in their community, and we're actually pulling lots of resources out of communities so that people can secure the release of their loved ones. But under the new system, that's not going to happen anymore. It's an in or out system. So you can imagine that if we made every charge eligible for detention, some prosecutors and some judges would continue to jail people who are accused of low-level crimes, drug possession, shoplifting, etc., and those people would have no way of getting out. And so you could actually have a worse system. There's a way that you could abolish money bond and have even more pretrial incarceration if you weren't thoughtful, as the drafters of this law were, about creating bucket of charges that are eligible for detention, and then the certain less serious ones that are not eligible for detention. So here's this flow chart is similar to the flow chart that M showed you, showing how the old system works. This shows how the new system works. So what the new system under the Pretrial Fairness Act does is it seeks to maximize opportunities for release at every point in the system, starting with when the person is arrested. So for the lowest level charges, for these ordinance violations, these low level misdemeanors, there is no longer a custodial arrest. What will happen in those cases is is police, instead of taking the person to a jail and a lockup and await seeing a judge, they'll issue the person a summons to come to court on a particular date and send them on their way. And there is a second group of charges, certain misdemeanors and low-level felonies, for which that's an option. If the police feel it's appropriate, they can do that, but they don't have to do it. For the lowest level charges, though, they have to issue a summons and not take the person to jail. And now, for everything else, though, for either a more serious charge or a charge that's where the police could issue a summons, but they've elected not to, and they've made a custodial arrest, then the person will be taken to jail, or they'll be processed and booked, and they'll see a judge. And instead of the bond hearing that we had under the old system, where it's generally a really short hearing where people, the central question is what is the monetary bond amount that's going to be issued. Instead, the first appearance is, where it's determined whether the prosecutor is going to ask for detention or not, and if they don't, then the person will be released, perhaps with conditions. But if the prosecutor is asking for detention, then they'll have a detention hearing, and they may have it that day, or they may set it a couple days in the future to allow the two sides to prepare. Because the detention hearing is this adversarial hearing in which the prosecutor needs to show clear and convincing evidence that the individual who's accused will either pose a danger to somebody else or would be likely to willfully flee. And then the defense attorney can make arguments and put on evidence to indicate that that's not true, and the judge makes a decision. And so the person then can be released with condition, or they can be detained. And again, if they're detained, there's no ability to secure release by paying cash bond. So that's how the new system works. Another principle that is underlying this law is that people should be viewed holistically, and we shouldn't use risk assessment tools, and I'll explain what that is here in a second, as a substitute for individualized decision making by a judge. So risk assessment tools are these kind of, you hear a lot in the news about artificial intelligence right now. This is like a really it's an algorithm an algorithmic tool that is used in courts, not always, but in many courts. Cook County and other counties in Illinois have used risk assessment tools for a while. And, so these algorithms use inputs mostly, the data that's inputted mostly has to do with criminal history, a person's past history of arrest or convictions, et cetera. And it basically spits out a score that tells the judge how, according to the information that's inputted, what does this algorithm think is the risk that somebody is either going to be rearrested for a violent crime, or that they will fail to appear in court. And these tools are, used by judges to guide their decisions in whether they are going to detain somebody or not, or to assess the risk of that they're supposed to, on the questions that will determine whether somebody's detained or not. The difficulty, or one of the difficulties, is these tools are have a lot of embedded racism, because you can imagine when the sole, the main input is criminal history. Well, what do we know about who gets arrested and who's more likely to have a criminal history? Because some neighborhoods are over-policed, some people are profiled. We know that that racial disproportionality that results in more, the racial disproportionality in the criminal legal system itself is going to be reflected in that data, and is going to show that people of color are, more risky to release. So, these risk assessment tools have the ability to kind of reinforce and buttress this racism that's embedded, and sort of give it the imprimatur of science or something. And we have real concerns about the overuse of risk assessment tools, whether these tools are really effective or should be relied on. So what the Pretrial Fairness Act says is the risk assessment tool can't be and won't be the determining factor of whether somebody's in jail or not. It's a tool, but the judge is the ultimate decision maker. And it allows defense attorneys to challenge the criteria of risk assessment tools, and it also kind of recasts the way that failure to appear in court is treated. Because what we know about when people fail to appear in court, most of the time it's not because they ran away or they hopped on a plane to another country to escape prosecution. It's because they forgot, or because they missed the bus, or they didn't have childcare that day. It's like the very practical reasons why people miss court. And so when we look at risk assessment tools and what constitutes a willful flight, which is the standard under the Pretrial Fairness Act, it's not just merely, do we think you're going to fail to show up because you had a lot going on and you forgot your court date. It really is focused on who's going to run away because they're trying to flee prosecution. And so for the purpose of risk assessment tools, we don't worry, we don't focus on non-appearance in court as much as we look at willful flight. And so the fact that somebody failed to come to court one time shouldn't be held against them as a reason why they're never going to come back to court and they need to be held in jail. We have to take a more nuanced view of that. Under the Pretrial Fairness Act, courts actually need to help people attend court hearings, and are not expected to restrain people's freedom while they're innocent and awaiting trial, but rather to make sure that we're doing everything that we can to get people into court. What we know is actually effective to ensure people's return to court is things like text message reminders, phone calls, bus passes, transportation. A lot of the problems with people failing to appear in court can be remedied by those things. But we know that currently what happens when somebody fails to appear in court is a warrant gets issued for their arrest, and they're sometimes facing a whole brand new case. And so this new law doesn't say that can't happen, but it says that what really should happen and what judges are encouraged to do is to contact the individual, to send them a summons that they missed court, they need to come back and attend court, and not send the deputies out immediately to make an arrest. So there's a little bit more of understanding that that failure to appear in court is not always a nefarious thing, and that there are things that courts can do to improve rates of court appearance without immediately issuing a warrant for everybody's arrest who doesn't show up. Another thing that this law does is it puts some guardrails around the use of electronic monitoring, because a lot of times when somebody is released pre-trial, increasingly they're released with one of these ankle shackles that is, supposed to be, it's a condition of release that is really overused, and there's really not a lot of good research that indicates electronic monitoring is effective at all. And what we've seen certainly in Cook County, where they have one of the biggest electronic and most restrictive electronic monitoring programs in the country, is that people are really, it's not merely it's not an alternative to incarceration so much as an alternative form of incarceration, where people are basically on 24-hour house arrest in their own homes. They can't do things like take the garbage out or get groceries or pick their kids up from work, or just do the things that anybody needs to do to function as a person. And then the equipment is often faulty, so people get reincarcerated based on malfunctioning equipment, or the fact that they were, they went out to the alley to take out the trash and it sent out an alert. So under the new law, there are limits in how, the severe the consequences can be when somebody is on electronic monitoring and they're alleged to have violated it. So, while there are still consequences, one thing that happened under the old law is people were often charged with a brand new offense of escape, which is a felony. And, people who were not trying to escape anything, but who were, merely found to, in violation of their electronic monitoring. So that is curtailed, as well as people who are put on electronic monitoring are now, under the new law, given a certain amount of movement during the time that they're on electronic monitoring to do those essential tasks that like go to the grocery store or pick the kids up from school. They can't just be on house arrest 24/7, because that's essentially like being in jail. Go to the next slide. So I should have put that slide up as I described the electronic monitoring reforms, but there they are now. So, and then I didn't mention it, but people who are on electronic monitoring, if they're ultimately convicted of the charge, they will get credit for the time that they served on electronic monitoring, the same way they would get credit if they had spent time in a jail. So the next principle is that that courts should only use restrictive pretrial conditions to ensure court appearance for people who are willfully avoiding prosecution. So this is that new willful flight standard. It's not simply that failure to appear in court is the thing that we're worried about, but what we're worried about is people who are going to abscond. And so that's what courts are focused on when they make a determination about risk of somebody, failure to appear in court is risk of willfully fleeing, not risk that they're going to miss the bus or forget. So the Pretrial Fairness Act provides that that pretrial practices should be transparent and accountable, meaning there needs to be data collection and reporting around how the new system is working. So the courts are mandated under this law to collect and report data about basic questions like how many people are being detained, why are they being detained? Is it for safety reasons? Is it because of a risk of willful flight? Where is this happening? In different counties, what are the practices looking like? What are the demographics? The racial makeup of who's being detained versus who's being released. And so all of this is going to give us a picture into the new system that we never really got into the old system. and will allow us to make sure it's working the way that it's supposed to. And if there are trouble spots in certain parts of the state, to identify those trouble spots and address them. But the new system will, you know, it's certainly not a perfect system that we're replacing, and the Pretrial Fairness Act won't be perfect, you know, itself. There will be a process of figuring out what works best for everyone, and if there are unintended consequences, or if there are system stakeholders that are trying to do an end run around or avoid some of their responsibilities under the new law, that we need to find out and address that. And the data collection is one of the tools that we have to do that. So how does this law make us safer? Well, there's no safety in a system where finances determine who's in jail and who's not. So the Pretrial Fairness Act makes us safer by ensuring that that's not the question that we're spending time on, but rather that courts are spending time on the question of safety and flight risk. We talked earlier about the trauma of incarceration itself on people, and the fact that people are actually more likely to be rearrested if they've been through that. And so by decreasing the overuse of pretrial incarceration, we hope to see, you know, fewer people cycling repeatedly through the system. Several jurisdictions that have eliminated money bail or greatly reduced its use have shown positive results in terms of crime not increasing and often decreasing substantially. So a lot of people talk about, I want to talk a little bit about allegations of, well, I'll go back, talk about allegations of violence, because a lot of people talk about bail reform as, you know, pertaining only to nonviolent charges, or that, you know, sometimes they'll misstate and say that, like, well, Illinois has eliminated cash bond for nonviolent charges. Illinois has eliminated money bond for all charges, violent, nonviolent. There is no more money bond in Illinois, and, you know, because the presumption of innocence applies to everybody. If the fact that you've been accused of something serious doesn't mean you're guilty of something serious. You're still entitled to that presumption of innocence. You know, that doesn't mean, you know, that everybody's released, though. It means that we're focused on focusing judges on questions of safety, whether it's, you know, really truly would pose a threat to any individual or the community to release somebody, not just because that they've been accused of something very serious. So, because people are, you know, accused of serious crimes and then not found guilty of those crimes. So, if we're losing sight of that, we can do real harm. So this is the law now. It's been the law for 2 weeks. The sky hasn't fallen like, you know, many of the critics of the law said it would. But, you know, there's still it's been a long road to get here, and it's a long road ahead. We know that the people who have been criticizing this law, filing lawsuits about it, perpetuating misinformation and saying there's going to be a purge, or, you know, other things that they've said, that, you know, the jail doors are going to fly wide open, and dangerous criminals will be roaming the streets. Somebody will be trespassing on your property and the cops won't be able to, you know, do anything about it. Those are some of the lies that have been told. And we know that those lies aren't going to stop. That, you know, in fact, they're probably going to, there's going to be a new round of misinformation now that the law is in effect. Every, high profile incident of crime or violence, there are going to be people who are like, look, it's bail reform, that's why this happened, as if none of these things happen under the current system with people purchasing their release with money. The lawsuits that were filed that, you know, we're claiming this law is unconstitutional. You may have heard the Supreme Court heard that case and found, no, this law is constitutional, and that's why it's now been implemented. But, the plaintiffs in those lawsuits were 60-some sheriffs and state's attorneys, elected officials in Illinois, and these are the same people who have duties to carry out under this law to make sure that it works the way it's supposed to do. So this is why it's important that we hold these folks accountable and make sure that they're doing what they're supposed to be doing, they're following the law, and they're not undermining it. And when they lie about it, we need to call them out and tell people what the truth is. And that's part of the reason why we are doing things like this teach-in, is because there's so much misinformation out there about this law that we need to get the word out in communities about what this law is, what it's not, what it does, what it doesn't do. And, we don't necessarily have the big megaphone that an elected state's attorney or sheriff does, or the authority of a badge that, gets them platformed in every media story. So part of what our network is doing community education. We're also doing court watching in different parts of the state. We are getting dozens of volunteers to go into courtrooms and actually take note of and write down data of what's occurring in those courtrooms, in order to to try to hold the system accountable and find out where things might be going well or not going well. We also have we're getting the word out about what people's rights are under the new law. So if you come see me after this, I have some little wallet-sized Know Your Rights guides about what the new law does, what happens when somebody gets arrested under the new law. And so we know it's going to be a long road ahead, still fighting against these forces who never wanted this law to begin with, who wanted to continue the status quo of wealth-based pretrial incarceration and sort of treating the presumption of innocence as something that doesn't really matter, or that's only available to people who have access to money. We're at a moment where we should be celebrating, but we should also be, cognizant of the fact that there are the folks who tried to stop this law are going to continue to try to chip away at it, and we're really happy to have you hearing this message, and if you're interested in getting involved in this fight, there are you can contact us, you can, be part of court watching, you can, if you'd like to organize another teach-in or invite us in somewhere in a community where you think folks need this information, please do that. So I'm going to go ahead and just wrap up, and if there are questions that you have for Em or for myself, then we're happy to stick around and answer them. Thank you. Yes.
Is court watching the only means for watching? You mentioned that sheriffs and others have new duties now. Could you explain what those new duties are, and how does court watching monitor them?
Well, I think the main folks are sheriffs certainly preside over the jails, but in the courtrooms themselves, it's, I think, the prosecutors and judges that we're really watching the most, because prosecutors have the duty to either move for detention or not move for detention, and to present evidence and arguments for those that they want to detain, and courts, judges have a responsibility to implement that law and make sure that those burdens are met before they order somebody detained. And so court watching is a means of determining whether that's, is that proceeding the way it's supposed to. Oh, okay.
your legislators. So if you sign that, I'll make sure it gets where it needs to be. And again, thank you so much, everyone. This was wonderful. You all are wonderful.